Section 12 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 6. Tribal Custom of the Franks and of the Tribes Conquered by the Merovingian Kings. Part 1. 1. The Virgils of the Lex Salica. In turning now to the Lex Salica, the inquiry will again at first more or less be a study of Virgils. There are many difficult points in the construction of the Lex Salica, and the capitularies connected with it, which, after all the learned labor expended upon them, still remain unsettled. To attempt to discuss them fully would involve an amount of research and erudition to which this essay can lay no claim. All that can be attempted in this survey of the traces of tribal custom in the laws of the continental tribes is to approach their text afresh in the light of the Cymric evidence, as a tentative first step towards, at last, approaching the Anglo-Saxon laws from the same tribal point of view and from the vantage ground of our previous study of the survivals of tribal custom elsewhere. The Lex Salica had force apparently at first over the Franks of the district, extending from the Corbonaria Silva on the left bank of the Meuse to the river Loire. The earliest manuscripts of the Lex Salica are considered to belong to the late 8th or early 9th century, and the general opinion seems to be that the first 65 chapters may be ascribed to the time of Clovis, or at least to a period before Christianity had become general among the Franks. The reign of Clovis extended from AD 481 to 511, and may perhaps be taken as covering the date when the 65 chapters were first framed. There is, however, no proof that they were not modified afterward, for at the end of the celebrated chapter De Chronecrida, there is a clause in a later manuscript which implies that it was no longer in force. If these 65 titles in their original form really go back to the time of Clovis, the fact that they were allowed to continue in late issues of the Lex Salica, along with the additions made to it, is probably enough in itself to excite suspicion that even these may not have been allowed to remain as they originally stood without modification, particularly on the question of homicide and the liability of the kindred of the slayer in the payment of the Virgeld. It is difficult to understand how the clauses relating to its payment and receipt, if representing fully more ancient custom, could have been left altogether unaltered after the decree of Childebert II, A.D. 599, which may be translated as follows. Concerning homicides, we order the following to be observed, that whoever by rash impulse shall have killed another without cause shall be in peril of his life, for not by any price of redemption shall he redeem or compound for himself. Should it by chance happen that anyone shall stoop to, make or receive payment, no one of his parents or friends shall aid him at all, unless he who shall presume to aid him at all shall pay the whole of the Virgeld, because it is just that he who knows how to kill should learn to die. The logic of this decree is curious. The slayer's kindred were absolved by it from liability if they chose to stand aloof, but if they stooped to help their kinsman at all, they must see to it that the whole Virgeld was paid, no doubt to avoid breaches of the peace from attempts at private revenge, if any part were left unpaid. But if the slayer's relations did not pay the Virgeld, what then? The slayer was left in peril of his life. From whom? It must have been from the vengeance of the slain man's kindred. One would have thought that this decree would have defeated itself, for apparently, whilst it absolved the murderer's kindred from obligation to assist the murderer to pay the Virgeld, It left untouched the right of vengeance on the part of the slain man's relations, thereby, one would have thought, multiplying cases of breach of the peace. That clauses relative to receipt and payment of vergeld were left in the lex after this decree shows, probably, that the system of vergelds remained practically still in force. People went on living under the lex salica after the date of the edict, and in spite of the latter, no doubt vergelds were paid and received. But whilst this may have been a reason why the clauses regulating the payment and receipt of vergelds could not be altogether omitted, it may also have made necessary the modification of some of their provisions. One may even venture to trace motives in the making of modifications in favor of the fisc, which can hardly have had their root in ancient tribal custom. The system of vergelds was extended to the advantage of ultimately both official and clerical hierarchies, and even from the Franks themselves to strangers and to the Gallo-Roman population amongst whom they dwelt. And the whole character and system of the Lex Salica was so much like a statement of crimes and the composition to be paid for them, that it lent itself very easily to the interest of the fisc. In the 65 titles themselves, there is direct evidence that tribal tradition and the solidarity of the kindred had once existed, and that in spite of the edict, the fisc was interested in their maintenance. Thus, by Title 60, de eum qui sede parentia tolera vult, a door was thrown wide open for the Salic tribesmen to escape from the obligations of kindred. To secure this object, he is to go to the malice with 3 branches of alder, and break them over his head, and throw them on 4 sides in the malice, and declare that he withdraws from the oath, and the inheritance, and everything belonging to the parentia, so that thereafter, if any of his parentes either is killed or shall die, no part either of the inheritance or of the composition shall pertain to him, but all go to the fisc. If we take this clause strictly, it implies and sanctions the general right of a kinsman of a slain person to share in his vergeld. The share of the kinsman, who under this clause frees himself from the liability to pay, and gives up his right to receive any portion of the vergeld of a relative, does not lapse altogether, but is apparently kept alive for the fisc. This clause is not perhaps inconsistent with the edict which left the receipt of vergeld still possible, though payment by the slayer's kindred was optional, and so long as the occasional receipt of vergeld was still possible, rules for its division might reasonably remain in the lex. The same may perhaps be said of other clauses, included in the original 65, Title 62. Decompositione homicidi is the one which deals with the division of the vergeld by its recipients, i.e., the kindred of the person slain. According to the text of Hexel Code 1, it is as follows: Si cumsque pater oscius ferit mediatium compositionis filia colleget, et alium motiatatem parentes qui proximores sunt tam de patriclam de matra inter si dividant. If anyone's father be killed, the sons are to take collectively 1/2 of the composition, and the other half is to be divided between the parentes who are proximiores, both of the paternal and maternal kindreds. Quod si de nulla paterna sia materna mollis parens deferiet, illa portico in fisco collegigatur. But if there be parentes on neither side, paternal or maternal, then that portion, i.e. the second half, is to go to the fisc. According to this clause, in the absence of the parentes, their half share still has to be paid by the kindred of the slayer, but again the fisc gets control of the lapsed portion, which the parentes would have taken had they been forthcoming. Among some clauses said to be added to the Lex Salica by Childebert I, AD 515 to 551, is a very important one, Title 101, De Hominum Ingenia Occusa, which seems to show that at that date, composition was still encouraged by the law, but that some alteration was necessary in the division of the vergeld amongst the kindred of the slain. Sici homini ingenium occideret et illi qui occideret, probitum furit, ad parentibus debet secundum legum comperine, media composiani filius haberi debet, alia mediati excendi et debet et ad quota dilud illa adventiat, alia quota pars parentibus propinquis demet, id est tre degeneration patris et tres degeneratione matris, si mata viva non ferit, media parti deleti illi parentes iter dividant, hoc est tre de patre proximoris et tres de matre, iter talem qui proximoris furient parentes de predictus conditionabilis predant. If anyone shall have killed a freeman, and he who slew shall have been ascertained, he ought to make composition according to the law of the parentes. The son, code 2, sons, ought to have half the composition. After that, of the other half, it ought to be for her, the mother, so that she comes in for a quarter of that luda or vergeld. The other quarter ought to go to the near parent, i.e., 3 parentia, of the kindred of the father and 3 of the kindred of the mother. If the mother shall not be alive, the half luda vergeld, those parentes divide amongst themselves, i.e., the 3 proximores, i.e., nearest parentes, of the father and 3 of the mother, but so that the nearest parentes under the aforesaid conditions shall take 2/3. Et tre partes illis duabus dividatum dimitat, et nam et illis duabus illa qui proximia furit, illa tertia parte duas partes pentit, et tertia parli patre suo derbitat. 3 parts again it leaves to be divided between the other 2 parentia, for also of those 2 the nearest parentia takes 2/3 and leaves 1/3 for the parentia of the previous ancestor. There must have been some special object in the addition to the lex. Brunner, following the very plausible suggestion of Willer and Borutius, points out that the mother, who, if alive, is to share in the second half of the vergeld, may be the mother of the son who takes the first half, i.e., the widow of the person slain. Otherwise, why should the mother alone be mentioned and not the father of the slain? If this view may be accepted, the object of the clause becomes at once apparent. Under Title 62, no share is given to the widow, and we have learned from the Kimrick example the reason why tribal custom gave no part of the vergeld of the husband to the widow. It was simply because there was no blood relationship between them. The widow and her kindred would have taken no part in the feud, and so took no part of the Galanas in composition for the feud. The silence of Title 62 and the force of the Kimrick precedent warrant the inference that it may have been so also under ancient Salic custom. However this may be, the fact that an addition to the lex was made, whether in favor of the widow or of the mother, seems to show that Roman and Christian influences had introduced other considerations than those of blood relationship, so breaking in upon tribal custom and necessitating special legislation. If this view may be accepted, and if, as we had to do in interpreting the Brehon rules regarding divisions of the kindred, we may take the word son as meaning all the sons, and insert the word parentia in explanation of the 3 proximores, so as to understand them, as in the Brehon Gelfinis division, to be not 3 persons, but 3 groups of kindred. Then these clauses become fairly intelligible and consistent with Title 62. The Vergeld is divided into two halves, and the second half, subject to the newly inserted right of the widow or mother of the slain, goes to the three groups of proxy amoris. What these three groups of parentia may be is not very clear. The father has been killed, and his sons take the first half of the Vergeld. The other half is taken by the three nearer parentia. The nearest group at first sight would be the descendants of the two parents of the slain. The second group would be the descendants of the four grandparents of the slain. The third group should include the descendants of the 8 great-grandparents of the person slain. But Brunner had pointed out that the division into paternal and maternal lines of relationship begins with the slain person's grandparents, so that the three proxy amoris on both sides should go back to the descendants of great-great-grandparents. He also points out that, as each step, the nearer group are to take 2/3 and those behind it 1/3. The division between the three groups would be in the proportion of 6:2 to 1, and he quotes a statement regarding the division of Vergelds in Flanders in the year 1300, in which the proportions of the payments of the three groups of relatives were still as 6:2 to 1, the half falling to the three groups being reckoned as 18/36. The division was as under. Rücksphere, Geschwisterkinder, i.e. first cousins. Paternal, 6/36. Maternal, 6/36. Antispheres, Andergeschwisterkinder, i.e. second cousins. Paternal, 2/36. Maternal, 2/36, equaling 18/36. Der Gelinge, Drittgeweisterkinder, i.e. third cousins. Paternal 1/36, maternal 1/36. We may then safely, I think, follow Brunner's cautiously expressed conclusion that it is very probable that also in the Lex Salica under the words tres proximoris are intended relations belonging to three separate parentia. So far we have dealt only with the receivers of the Vergeld. We have now to consider the Vergeld from the payer's point of view. When at last we turn to the title, Die Kernana Cruda, which deals with the payment of the Vergeld by the slayer and his kindred, we seem all at once to breathe in the atmosphere of ancient tribal custom, before it had been materially tainted by the new influences, which the conquest of a Romanized country and migration into the midst of a mixed population necessarily brought with them. The force of tribal instinct survives in this clause, even though since the edict of Childebert II, it may have been allowed to remain in the lex partly on sufferance, and even though some of its details have been made incoherent by the mutilation it may have undergone. It was probably left in its place in the lex, together with the clauses regarding the receipt of Vergeld, because, even though the assistance of the kindred in the payment of Vergeld had been made optional and discouraged, the instincts of kindred were not to be extinguished all at once. To save the life of a kinsman will sometimes exercise the option, and the slayer, before he flees for his life, will make his appeal to his kinsman. The old traditional rules for payment will have force in the feelings of those who, under all the discouragements of the law, still choose to assist the slayer. Moreover, the malice, it appears, still exercise jurisdiction over the option. This celebrated clause may perhaps therefore be quoted as evidence for so much of ancient tribal custom as to Vergelds as the royal edict was unable to extinguish all at once. Difficulty arises chiefly from the imperfect condition of the text of one of the clauses, but, keeping close to Codex I of Hessel's and Curran's edition, the following translation may pass for our purpose. Title 63. 1. Si quis hominem occiderit et, totum factulatum data, non haberit et, unde tota lege compliet. 12 jurataris donar debet quod, nec super terram nec subtis terram, plus facultatum, non habeat quam jam donavit. If anyone shall kill a man, and, having given up all he possesses, he yet shall have not enough to satisfy the whole legal requirement, he ought to give the oaths of 12 co-swearers, that neither above the earth nor under the earth he has any more property than he has already given up. 2. Es postea debet in casa, sua intra, et dequater angelus terri in pugno collegeri, et sec postea in durapolo, hoc est in limitari. Stari debet intus in casa recipiens, et sic de sinistra manum de illa terra trans scapulas, suis jactari, super ilium quem proximiorum parentem habet. And afterward he ought to enter into his house and to gather earth in his hand from its 4 corners, and after this he ought to stand on the threshold, looking back into the house, and so from his left hand throw across his shoulders some of that earth over him, those whom he has nearest of kin. 3. Quod si jam pater effratus sulsurant, tunc super suos debet illa terra jectari, it as super tres degeneratorium, matris as super tres degeneration patris qui proximoris sunt. But if father and brothers have already paid, then over his relations he ought to throw that earth, to wit, over 3 parentees of the kindred of the mother, and over 3 parentia of the kindred of the father, who are nearest of kin. 4. Et sic postea in canicia, distinctus, discalicius, palo in manu, sepi sali debet, et pro mediati, quantum decomposiani diger est, et quantum lex adicat, illi tres solvant, quoc illa alii qui de paterno generatione venient facere debent. And likewise after that, in his shirt, ungirded, unshod, stake in hand, he ought to leap the fence, so that for that half those 3 shall pay whatever is wanting of the composition, or what the law adjudges, that is, those others who come of the paternal kindred ought to do so. 5. Si vero de illis circum proximor verit, et un habeat unda interregnum, debitum salvat. Circum de illis plum habet interum super ilium credit cruda illa qui purpura es jecit ut illa tota legi solvant. But if any very near kinsman shall be unable to pay the whole amount due, then whoever of them has more, on him again let the one who is poor throw the cruda so that he may pay the whole amount due. 6. Quam si vero nec ipse haberit, unde tota perselat. Tunc ilium qui homicidum, fecit qui eam subfidum habeut de in malo presentari debent, et sec postea eam perquata malus et suum fidem tollant, et si in compositione nullus et fidem tolerant, hoc est et redimant dico domino persevat, tunc de sua vita compodat. But if not even he shall have the wherewith to complete the required amount, then those who held him under oath ought to produce him with committed the homicide in the malice, and in the same way again afterwards 4 times in the malice, hold him to his faith, and if no one can take up his faith concerning the composition, i.e., to redeem him by payment, then let him make composition with his life. Now, if we are here dealing with actual tribal custom, it is natural to place some weight upon the picturesque incidents which testify to its traditional origin. These picturesque incidents can hardly be other than proofs of antiquity. Let us try then, in spite of some confusion in the text, to make out the probable meaning of the action described. Clause 1 makes it clear that the first public step taken on the part of the slayer was to go to the malice with 12 co-swearers, who, with him, pledge their faith that he has given up everything, above ground or below it, towards the vergeld. There must have been previous negotiations with the kinsmen of the slain, and a stay of vengeance must have been conceded on the understanding that if possible the vergeld will be paid. Having thus obtained legal security for a time, the next stage in the proceeding is one between the slayer and his kinsman, without whose help he cannot pay the vergeld. The graphic details of the second clause seem to involve the presence of a family gathering, met within the enclosure containing the house of the slayer, and, for anything we know, other houses of near relations. In this enclosure the kindred have met to deal with a family catastrophe, in which they themselves are involved as well as the slayer. Even if they have to find only their half of the vergeld, 50 head of cattle from the family herd, or their separate herds, as the case may be, must be to them a matter of importance. Standing on the threshold of the house from the four corners of which the slayer has gathered a handful of earth, he throws it over the representatives of his paternal and maternal kindred. He has done his part, and now the responsibility rests on them. The vagueness and difficulty of the next clause result from a text which has probably been tampered with, but with the help of Title 62 and the addition of Title 101, giving further details, it becomes at least partly intelligible. The rule that the payment of vergeld was made by the relatives in the same proportions as they would receive it if one of their kinsmen had been slain is so general that we may fairly assume that it was followed also by the Salic Franks. We have seen that according to these clauses, if a father was killed, the sons took the first half of the vergeld, and that the other half was divided between 3 sets of proxiamores, the 3 parentia, or sets of relatives of both paternal and maternal kindreds, in certain proportions. The slayer and his son should pay the first half, and his father and brothers apparently help them to pay it. The other part ought to fall upon the 3 parentia nearest of kin on both the paternal and maternal side, so that clause 3 becomes partly intelligible. If the father and brothers have already paid what the slayer could not pay of the first half, the earth has to be thrown upon the 3 parentia nearest of kin of the mother's kindred, and of the 3 parentia nearest of kin to the father's kindred. These seem to be the proximores who should pay the other half. The phraseology of the Title 62 and 101, and the analogy of other tribal custom seem to warrant the conclusion that here also the 3 proximores on the paternal and the maternal side were originally not 3 persons next of kin, but the 3 parentia, i.e., according to Brunner, the descendants of the grandparents, the great-grandparents, and the great-great-grandparents of the slayer on both the paternal and maternal sides. The next clause is the one which bears clearest marks of having been tampered with. It makes no sense when strictly construed, but it seems to contain 2 ideas. First, that there may be a deficiency as regards the second half of the payment, and secondly, that the persons who ought to make it up are those others who come of the paternal kindred. The question who are intended by these words is one not easily answered decisively, nor is it one upon which we need not to dwell. It is to be regretted, however, that at this critical point the text is so sadly confused, for it must be borne in mind that if no relative was liable beyond those included in the phrase, the 3 proximores, then the liability to pay and receive vergeld under Salic custom was restricted to the descendants of the paternal and maternal great-great-grandparents, and whether it was so in ancient custom is just what we should like to know. Be this as it may, the slayer has done what he could in throwing the responsibility upon his kindred. He knows not, perhaps, whether they will fulfill the obligation thus cast upon them. He has given up everything he himself possessed, and now in his shirt, ungirded and unshod, he leaps over the fence of the enclosure with a stake, palace in hand, to wander about in suspense until it transpires whether the rest of the Vergeld will be found or not, whether those who ought to assist him, whoever they may be, will help him in his need. Clause 5 seems to state merely that the liability of the proximores is collective and not individual, so that the poor in each group of relatives are to be assisted by the richer, and we need not dwell upon it. Lastly, Clause 6 brings the slayer, after all his efforts and appeals to his kindred, face to face with the final result. 4 successive times his co-swearers had brought him up to the malice to hold him to his faith, and now at last, if no one steps in to complete payment of the Vergeld, he must pay with his life. This is the best we can make of the famous title in the Lex Salica regarding the payment of Vergeld, but perhaps it is enough, when taken together with the clauses relating to its receipt, to reveal the main points of every Salic tribal custom. We may state them thus: 1. That the Vergeld was divided into 2 halves, for one of which the slayer, helped by his father and brothers, was responsible, and for the other of which the 3 grades of kindred, extending apparently to the descendants of great-great-grandparents, were responsible. 2. That if the addition of Title 101 represented ancient tribal custom, the payments, like the receipts of the second half, were so distributed that the nearer parentia or group of relatives paid and received, in relation to those behind them in kinship, in the proportion of 2/3 and 1/3. 3. That if we may take the addition of Title 101 as giving a share to the widow, and as an innovation, then it may fairly be concluded that under ancient Salic custom, as under Cymric custom, the widow originally took no share in the Vergeld of her husband, not being a blood relation to him. Further, as in the title degenerated, there is no mention of any share in the payment of Vergeld falling upon the wife of the murderer or her family. We may conclude that however closely 2 families might be united by a marriage, the wife, for the purpose of Vergeld, still belonged to her own kindred, and that marriage did not involve the 2 families in mutual obligations for each other's crimes of homicide, until both paternal and maternal kindreds became sharers in payment and receipt of Vergelds in the case of the children of the marriage. It is not needful to follow the speculations of various authorities as to what became of the homestead and landed rights abandoned by the slayer when he threw the crenacruta upon his kindred and leaped, ungirt and unshod, over the fence of the enclosure. It is begging the question to call it his Grundstück, in the sense of a plot of land individually owned. Whether it was so, or whether under Salic custom land was held by family groups, as in the case of the Cymric Gweli, is what the clause degenerated does not tell us. The question may perhaps have easily solved itself. The homestead and grazing rights under tribal custom might probably simply merge and sink into the common rights of the kindred, i.e., the neighboring kinsmen would get the benefit of them, even if the slayer, now himself slain or in exile, had held a privileged or official position as chief of his family. It would not follow that his successor, having doubtless already a homestead of his own, would care to succeed to the one left vacant. It is much more likely that tribal superstition would leave the murderer's homestead to decay. Even the sons of a person whose kindred had left him to perish by refusing the necessary help in the payment of the Vergeld of his victim might well refuse to uncover the haunted hearth of their father. The slayer would return to his old homestead. Finally, it must be remembered that in the tribal stage of land occupation, the value of land itself bore a very small proportion to the value of the cattle upon it, and so the Grundstück of the slayer would be as nothing compared with the value of the 100 cows of a normal Vergeld. End of section 12.